Good afternoon, everyone, and welcome to the Children's Commission webinar on navigating the transition from trial to appellate counsel. I'm Dylan Minch. I am the Legal Representation Director with the Children's Commission, and I'm very happy and lucky to be joined by a wonderful panel of experts that we've assembled for this topic. Michael Hull, the Assistant County Attorney with the Harris County Attorney.
There is a little bit, difference between the oral rendition and then when there's an order or a judgment, because the judgment kind of triggers your notice of appeal deadline. But if you've got a trial court that, orally at the end of a trial terminated parents' rights and listed out the provisions of the family code under what it was getting terminated, and you're having a hard time getting that trial court to sign a final judgment, nothing bad happens if you go ahead and file a notice of appeal. It's either going to be treated as a premature notice of appeal or, it's one of the things that you should just err on the side of caution.
Thank you so much, Lauren. I wanted to ask very quickly about cases that are severed. Is that a pitfall to watch for in terms of whether or not a judgment is final?
It doesn't happen often, I think, but yeah, you'll find quite a few cases where people were confused by severed cases. And I guess the biggest confusion is they'll file in the wrong case. Instead of the A case, they'll file in the original case and so on. And I'll give you an example. I can only find one case that involved a parental termination type, that also involved a severance order. But in that case, it was filed in the wrong case. It was filed in the one that wasn't final yet. But generally speaking, courts of appeals will accept jurisdiction if the appellant made a bona fide attempt to appeal and if there's no prejudice to the other parties. So in the particular case, which you'll get when you get the PowerPoint, it's cited in the notes, the court said, the opponent didn't show any sort of prejudice, and just because they filed it in the wrong case number, we'll accept jurisdiction and the notice of appeal is timely. On the other hand, there's a case out of Fort Worth where, and there's many cases along this line, where a notice of appeal wasn't filed in the severed case. I mean, if you have the idea that, a case is severed, typically it's severed to make one judgment final, we've already resolved these claims, so we're going to move them off to the side and sever that case, and then we'll carry on with the rest of these. That judgment that's final, that's severed, you have to appeal that now. You don't get to wait until everything's done. They're separate cases now. And that's what you'll find a lot of cases where that happens. Somebody will wait till both cases are ended to file the notice of appeal, and by that time the court has no jurisdiction. The order's done, final.
Relatedly, and Dylan, just so that there's some context, relatedly, I would say that you need to watch out for what we see sometimes, the interlocutory orders of termination that precedes the severance. That's kind of the trigger to know, hey, I need to be watching out for this interlocutory order of termination that is then severed to allow it to become a final order. So really, that's another thing that you need to watch out for, and it presents some issues on appeal as well, to make sure that interlocutory order was eventually made final. I have seen a case where the interlocutory order was not finalized, and the department later dismissed the whole case. And so that led to a somewhat unusual result for the father who had been terminated in a significantly earlier interlocutory trial.
Thank you, Mark. Just to be clear, the circumstance you're talking about is where one parent may be terminated and then the trial proceeds on the other parent.
Yeah, it could be, or there could be a situation where perhaps the father was unknown or not located yet, something like that, and the case proceeded to terminate his rights, but the mother, for instance, was granted a 6-month extraordinary extension, and so the case continued on, and the father is terminated within the 1 year, but the mother's case proceeds and then eventually gets dismissed. Well, what is the status when that final order of dismissal comes in? What effect did that have on the termination? And so that interlocutory order would have needed to have been severed and made final.
Thank you. I really appreciate it. Very thoughtful answer. Michael, did you have something you wanted to add?
I was just going to say, back to what we said the last slide, if you're in doubt, file a notice of appeal.
Right.
because there's no second chance. That's the only jurisdictional requirement in the to get in the appellate courts is the timely notice of appeal. Beyond that, you can screw everything else up. Don't screw everything else up, but you can. It's
But
not
you
going to
could.
cost you your case.
Right.
All right. Well, I want to transition next to talking about finality and de novo review, since a lot of child welfare cases are heard before associate judges. So what is the effect on filing a request for a de novo review of a judgment on the ability to appeal that judgment?
It's all stayed. Nothing happens. If you file a timely de novo review, then you don't have a final judgment, and none of your post-judgment deadlines start counting down.
Yeah.
So,
I 100% agree with that. If you did what you need to do in a timely manner, now there's occasionally I have seen some courts allow have the parties waive the de novo review and take appeal directly to the Court of Appeals. That's a somewhat different circumstance, and I think we talk about that in a second. But yeah, that's something that you can certainly watch out for too. But I agree with Michael. It stays the whole thing as long as you timely filed.
Okay. Do you have to file a de novo review if you want to file an appeal, or is that optional?
it's completely optional.
Absolutely optional, right?
Now, your district judge is still going to sign the judgment, but there won't be de novo review. But in theory, I guess the district judge could change something. I got to be honest, when I read chapter 201, my head gets a little dizzy. It's not the clearest thing to so if you've got questions about that, review chapter 201. And I guess first, before that, try to figure out what your AJ or master or referee or whatever it is you're dealing with, what statute they're appointed under. But even under chapter 201, there's 4 different sections that are generally track each other, but they're a little bit different. There's a few small changes in them. One of them deals with Title 4D AJs only, so that's not our issue in this. But the other 3, I don't know which AJ or which statute subchapter your AJ is appointed under, but you probably ought to try to figure that out first.
We talked a little about when a finality of an order. So what should people look for to determine when an order by an associate judge is final or not final?
Well, the first question is going to be, did anybody timely appeal? I mean, well, let's back up. The first question, as I indicated, was, did everybody waive? If everybody waived, then it would be final at that point using the same analysis we had in response to the first question. But after that, then the question then becomes is, did anybody timely file a notice of de novo, request for a de novo hearing?
And that has to be filed fairly quickly, correct?
Right. It's yes, within days, basically.
Yeah.
And
it's 3 days, 3 business days within
3 business days, right?
Yeah, within for under chapter 201. As we'll see in just a second, a little foreshadowing here. It's not always 3 days. There you go. But just for example, this master statute in chapter 54 and 54A of the government code, we have masters here in Harris County, and things are a little bit different there. So again, you should find out how your deputy judge, master, associate, or referee, whatever, find out what authority they're appointed under, because it may change what happens in that court. It may change the powers that the AJ or master has, and it may change some of the deadlines. So if you're going to be doing these kind of cases, you should probably figure out where your judge comes from, under what authority.
Lauren, is there anything you wanted to add regarding the de novo process? I know it's not something that you deal directly with the Court of Appeals, but I just want to make sure I got your thoughts.
No, I defer to Mark and Mike about this. This is, not something that I deal with really on a day-to-day basis.
Thank you, Lauren. So the next topic that I wanted to move on to is the right to counsel. So we know that the right to counsel for parents in TMC and termination cases attaches when they appear at the adversary hearing. But how long does that right to counsel extend? How far does it go?
All the way to the Supreme Court. I think the counsel is, there we go. There's the code. I knew you'd come through with the code section. Right, all the way to Supreme Court. And that is something that comes as a surprise, I think, sometimes to counsel who may be seeking to get out of the case at the end of the trial and saying, Judge, I would like to withdraw, and not every court has a giant appointment wheel from which to draw names to be replacing attorneys to handle appeals. And so if you signed up for the trial, or if you signed up for the appointment, you need to understand that under certain circumstances, you could be taking that appeal as far as you can possibly go. And I think that acts as a surprise to a lot of people.
Thank you, Mark. That leads us sort of directly into the next session that I wanted to talk about, which is the withdrawal and substitution of counsel. And what I hope we cover in this section is sort of some of the questions that I know a lot of people have, which is, why is it important to make sure that you're properly relieved? What do people need to do to make sure they're properly relieved? What are the special duties that a trial counsel has to do to make sure they preserve a client's right to appeal? But the first thing I wanted to talk about is kind of the point Mark made, which is withdrawal and substitution. If an attorney doesn't feel capable of handling an appeal, is withdrawal and substitution of counsel automatic? Or what Lauren, I might kind of turn this to you. What does a court look to see whether or not withdrawal is appropriate for this case like this?
Well, I think what's important to note is that when you're trial counsel, initially you're going to file your motion to withdraw in the trial court. And so that's not something necessarily the Court of Appeals deals with directly at the beginning. What I will say, though, is if you were able to do a trial, you can do an appeal. Like, they're not, don't be intimidated by them. You get on Westlaw, you do some research, you can figure out, what are the main issues that people tend to argue in these CPC cases or parental termination cases. So I don't necessarily want anyone to be scared that, I can't handle an appeal, because you can do it, And so I think maybe either Mark or Michael could speak to what the procedure is in the trial court as far as trying to get yourself withdrawn and a new counsel appointed, if you're just not going to do the appeal.
Michael, I'll turn to you.
I was in Harris County. It's pretty much a routine thing. The judges, when they give their final rendition, will often relieve the ad litem for the parents and appoint. Well, some of them appoint appellate counsel, then some don't. But I mean, typically it's kind of an automatic procedure, which sounds good in theory, but it doesn't always work well in practice. What we'll get to a little bit later in a few slides about why that should concern the trial attorney, but if you're in a county like Mark was saying, where it's slim pickings as far as appellate lawyers, if you take these cases at trial, you may end up with it, and you may end up with it even though the pay stinks, and you don't want to do appeals. You've never done an appeal, but as Lauren said, they're really not that difficult. And the good thing is you can look online in your local court of appeals, find some decisions on parental termination cases, and then pull the briefs. And, you can look at what other people have done, and at least you get a template. You see the kinds of arguments. And let's be realistic. I'd say 99% of the time, the arguments are just factual and legal sufficiency of the evidence. It's just a matter of gathering all the evidence and saying this was enough or not enough. And so there's no real deep legal research needed typically. And so, yeah, don't be intimidated by it, but you may be stuck with it.
I 100% agree with what Lauren said, is that you should not be intimidated by this. I am a firm believer in, if you do some appeals, it makes you a better trial lawyer. There is nothing quite as humiliating as seeing how bad you sound when you're reading your own transcript. And so it's a wonderful way to markedly improve what you're doing at trial. And you do, it's a learning experience every time. And so I wholeheartedly recommend to anybody who is a trial court, who considers themselves to be a trial court CPS parent representative or child representative, whatever the case may be, to consider doing an appeal. I am well aware that possibly the most intimidating thing to any lawyer is a blank piece of paper in front of them saying, all right, I've got to create a brief out of whole cloth. You do not. I agree with Michael. You can always go to the Court of Appeals website and download somebody else's brief and at least have a template of what it is that you're trying to do. Most appellate lawyers I have found are very willing to share, and that's good, are willing to share their stuff and help you out and help somebody out. But I strongly encourage everybody who is listening to this, and we're going to talk a little bit more about this soon enough, but to do an appeal, try it out, take it for a test drive one time. You may hate it, but at least you'll know you hate it because you tried it. It's like when you were a kid and your mom said, try the peas. After you try them, then you don't have to eat anymore because you know you don't like them after you tried them. It's the same thing. And I'd encourage everybody to try it out one time.
Can I add one thing, Dylan?
Of course, go ahead, Michael.
The case down there, JOA, just a few quotes from it. I think it's an important case. But in that case, that was back in the days when you couldn't just file a notice of appeal, you had to file appellate points. In other words, before even your notice of appeal was due, you had to decide what it was you were going to appeal, which sounds great if you're the trial attorney, not great, but doable if you're the trial attorney. But in that case, there were no timely appellate points filed. There was a timely notice of appeal. The trial attorney filed a notice of appeal, but the court didn't file or appoint appellate counsel till after the 15-day deadline. So the question there was effectiveness of counsel and that sort of things, but the question was whether the trial counsel was ineffective, even though, these were technically sort of appellate issues. And the court said trial counsel's failure to follow through with his representation until relieved of that duty was tantamount to abandoning his client at a critical stage of the proceeding. Counsel was seriously deficient for not filing points. Now, the court also takes the trial court to task a little bit. The Supreme Court takes the trial court to task because it's the trial court judges have some responsibility in this matter too, to make sure that there's a smooth transition and to make sure the appellate attorney knows they've been appointed. We've had problems with that issue. But the court says, given the accelerated timeline, the burden should logically fall on trial counsel. And in this case, necessarily so, because Timothy's appellate counsel was not appointed until after the 15-day period had run. And there's a concurrence by Justice Willett where he's basically saying, these types of cases where trial counsel does not handle things until appellate counsel is secured, and really, they should be referred to disciplinary authorities by the courts. And, I'm not aware of that happening on a wholesale basis, but it should be something that concerns appointed counsel.
Thank you, Mike. And I think that's a really interesting perspective the court articulated, that they sort of the post-trial actions of trial counsel are still part of that trial representation of whether or not it was effective. I think that's a really important point to consider. The next thing that I wanted to move on to was sort of how trial attorneys particularly, counsel their clients about the appeal and their right to the appeal. And Mark, I'll look to you. How, when you're in trial, do you counsel your client about that next step, sort of even before it happens, while you're still in trial?
Well, to be honest, that's what I think of as one of the most difficult things that attorneys do with their clients. And when you've gotten to a trial, and if you're even thinking about talking about appeal, something bad has probably happened. They've been terminated. They have lost their rights. They are upset. This is not a conversation to have when you're sitting in the courtroom or you've just logged off the Zoom and to have with the client. You need to sit down with your client and say, all right, we need to talk about appeal, because clients, generally speaking, have heard of the idea, well, I can always appeal. And what an appeal actually is obviously a review for error, not a second swing or a second bite at the apple, so to speak. And so that is many times an extraordinarily difficult conversation to have. And so there's a variety of different ways to do it. My recommendation to a trial counsel who is doing that is to write it down, whether it's in the form of a letter or an email or something like that, and say, these were the issues. This was the evidence that was adduced at trial, and not to be flip, but yeah, you tested positive 7 days before our final trial. You haven't visited the child in the last 3 months. Lay it out there. And it's a very difficult conversation to have, but the most important thing is to try, if you can, to get through to your client that this is not just a second swing. It's not, you didn't like the outcome. We have to say there was an error. Was the error preserved? You know, what do you need to look at your actions? And a lot of times we have clients who have challenges that don't allow them to really to shift gears like that correctly. So I've spent a great deal of time between after the final hearing, but before my notice of appeal is due, really counseling the client a great deal, multiple meetings, multiple phone calls, emails, that sort of thing, to ensure that they understand what needs to be done for an appeal. Because I'm not a fan, I'm going to say this, I'm not a fan of Anders briefs. And so when you go through these things, you know, you want to have, as Michael indicates, most appeals that you do it are going to be on sufficiency grounds. It's unlikely that you're going to have some laser focused error where somebody messed up. It's typically going to be a sufficiency of the evidence. Was it there? Was there enough evidence to sustain a finding of best interest, something like that? And so when you're having that discussion, it becomes a very hyper-technical discussion, as with any appeal. And getting the clients, as I indicated, many of whom have challenges, to understand that difference is very important. I have filed notices of appeal, and I'm sure Lauren has seen this. I filed notices of appeal to preserve the time, and then continued to talk to the client when I did not believe that there was an appealable error there. Or that the weight of the evidence was overwhelming to proceed. And then later, before the brief is due, typically I'll get a briefing schedule, but before the brief is due, the client says, you know what, you're right, I see the problem, I do not wish to proceed, and they withdraw the appeal. And I've noticed that courts of appeals are very welcoming to my motions to dismiss appeal. I find that I get wonderful response on those, usually very quick, very rapid, and I think that's the way that should be handled.
Lauren, is there anything you wanted to add to Mark's kind words for the appellate courts?
I mean, never going to turn away a motion to dismiss an appeal. I will say, you know, if you're having difficulty convincing your client or talking to your client that, you know, their case may not be a great one to appeal, or they might not have great issues, go ahead and file the notice of appeal. Check that box off, and then, as Mark said, keep talking about it. You know, we are in the Court of Appeals, we are monitoring parental termination and child protection cases very closely. Anytime anything gets filed, we're monitoring it. So that's part of the reason why, if we see a motion to dismiss, it gets handled very quickly, is because these cases are a big priority for the Court of Appeals. And so I will also say that, you know, I will not give my personal opinion on Anders briefs, but if your client is dead set on filing a notice of appeal and appealing, and you're an appointed attorney, either, you know, if you're going to continue on, Anders briefs are an option. There are certain situations where, you know, the evidence is clearly sufficient, or appellate counsel has that option. So, you know, if your client really wants to appeal, there are different situations and different ways that you can handle it, even if you don't necessarily agree with their final decision.
Dylan, I think the most important thing is what Lauren said, though. If nothing else, file your notice of appeal and get that, you know, check that box. And if you're the trial counsel, you know, we need to talk a little bit about the handoff. I think that's something we're coming up to. I think that'll probably be the next slide about the post-judgment duties, but file your notice of appeal, preserve that, so that if something comes up, it gives you, number one, it gives you more time to continue to talk to your client. But don't, especially if you're the trial counsel, if you need to file that notice of appeal, do that. But then if there is going to be a handoff, that handoff needs to be done. I will tell you that it is the case that sometimes the trial court doesn't necessarily let the appellate lawyer know that he's been appointed. There's a time lag there. And since we have a very short timeline, it is imperative that trial counsel, once you know you've been relieved, contact the appellate lawyer, you know, tell him, hey, here's my electronic file, here's what you need. Know that I have not yet filed a notice of appeal, but the client has indicated they want an appeal. Communication is critical at this stage because of the very short timelines between trial counsel and appellate counsel. And in addition to the trial counsel and the client, and appellate counsel and the client as well. So communication is the key to all of this section.
Actually,
Go ahead, Michael.
just one quick thing, both of them mentioned Anders briefs, so I guess I'll give my opinion. And since we don't write them, it's not worth much as an opinion, I guess. But for those that don't know, an Anders brief is when you don't have any non-frivolous issues, or you believe you don't, then you file what's called an Anders brief. They do it in criminal law all the time. A few years ago, the Supreme Court said we should do that in parental termination cases, or we can do it in parental termination cases. But generally speaking, if you're doing an Anders brief right, it's going to take as much time and effort or it should, as a regular brief. So, and I say that because in the past year or so, I've seen some appellate courts, including the Texas Supreme Court, kick Anders briefs back because they didn't think it was necessarily Anders worthy. And they, basically sent it back, appoint new counsel, because this isn't an Anders case. So as like Mark said, most of the time I wouldn't mess with Anders briefs. The reality is, if you file a brief that potentially could be Anders, nobody's going to grieve to you if it turns out all the points are, I can't see the Court of Appeals filing a grievance because, you could have just slapped the label Anders on top and all of a sudden you're protected. So my point is, Anders briefs recently seem to be grabbing a lot of attention, and the courts are actually pushing back on some of those. So if you're going to file an Anders brief, first of all, do it right. Read the case law that deals with it. Requires basically as thorough review and briefing as if it weren't an Anders case. So I would only do that. It would be a rare case where I would do an Anders brief if I were a parent's attorney.
Thank you,
That's all.
Michael. We've talked a lot about the specific duty of filing that notice of appeal, sort of almost kind of no matter what, but I want to talk a little bit more about some specific post-judgment duties that trial counsel has. And, one of them we know is from the Texas Disciplinary Rules of Professional Conduct, that they have to make sure that they still owe ethical duties to their client, even if they're planning to withdraw or have already withdrawn. But I wanted to talk about some specific actions that courts can do. So what are specific actions that attorneys can do to make sure that even if you're planning to withdraw and substitute, things they can do to make sure they protect both their client and themselves?
First, you want to go, Mark, or you want me to?
Go, Michael, if you want to go first.
I was just going to say, talk to the client. If they don't want to, I would definitely try to get it in writing somehow, or record it or something. So when the grievance comes a year later, you can pull that out and go, I counseled him or her, and they didn't want me to appeal, so I didn't appeal.
I want to jump in right there and say that, getting back to what I was indicating about filing the dismissals with the Court of Appeals, if you are going to file a dismissal, I urge counsel to make sure that you get your client to sign off, to countersign that with you when you send it in. I have had a situation where it came back and the client says, well, I never said that. And as Michael indicated, I did have some other writings in place that indicated that, in fact, they had. But I've found that the best practice under these circumstances is to add a signature line for the client underneath your own when you file your notice of dismissal of the appeal, and have them countersign it underneath you. That avoids a lot of problems down the road. And as I indicated, many of our clients, in fact, I would say a majority of our clients have challenges, mental health challenges. And so it is not unrealistic to assume that they may have not remembered that they told you could dismiss the appeal. And so these are the things that an attorney can do to protect themselves, and not the least of which is to make sure you get whatever your direction is in writing.
What about when they have that motion filed? Do they need to set a hearing?
It probably depends on your jurisdiction. I mean, here, the court's pretty much, if you file a motion, you have to set a hearing. But here, like I said, some jurisdictions, the courts pretty much are on top of that. They take care of it themselves. You just have to follow through to make sure. Well, we'll get to that, I guess, but yeah.
No, I agree with that. Typically the courts will handle that. I don't recall us ever having a hearing on the question of somebody wanting to withdraw. The judge usually handles that. You file, Judge, I wish to withdraw, and boom, very quickly, thank goodness, the judge will come back with an order that says, okay, you are allowed to withdraw, and, Mark, you are appointed to handle the appeal.
And if you're retained, obviously you're gonna have to file a motion. But yeah, with the appointment system, usually the courts take care of that. But you have to follow up to make sure they have taken care of it. That's still your responsibility. You can't rely on them.
And so when you file that notice of appeal, where do you file it?
You file it with the trial court clerk. If you mistakenly file it with the Court of Appeals, that's okay. It's still treated as filed on the day that you filed it with the Court of Appeals clerk, and they'll transfer it back to the trial court clerk. But yes, it gets filed with the trial court clerk.
That's one of those things that Michael was talking about, how the appellate courts are very forgiving of really errors. And so they come back and they'll clear that up for you.
I'm doing this 27 years. I've made every one of those errors, and
Right.
I can tell you they're very forgiving.
So we talked next about once you've got that order, if you get the order, secure to make sure that you have a copy of it. And then this is what you alluded to a little bit earlier. Once you've got the order, trying to make sure that the new counsel actually has the order. Can you talk a little bit how to try to communicate with the new counsel once they've been appointed?
I have found that email is by far the best way to do it, because you have a written record that you tried. And so typically you have email addresses for counsel. If you don't, most email addresses are available online. Most everybody has their own website, things like that. How do you contact us? Make sure that you have something that indicates that you attempted to contact appointed counsel really as soon as you get that. When I received the letter, or when I received the judge's order on e-file that somebody else has been appointed to substitute for me, for instance, then I'll contact them and say, all right, here's the file.
And to follow up on that, we've added that last phrase there: suggest issues and points for appeal. We've had appellate counsel mention that at times. It's such a short deadline. It would be nice if trial counsel were to, again, most of the time it's going to be factual or legal sufficiency, but it would be nice if they gave me a little bit more detail, so I had some idea, regarding, do I need to file a post-judgment motion? Do I need a record of voir dire? When the reporter's record is made, can I do without that, and all that kind of stuff? But it's not a bad idea to write a couple paragraphs down, and you could say, the O ground's pretty solid, but E is pretty weak. Attack that one, and because there's consequences to having the E ground, long-term consequences.
I agree. I understand that a lot of times trial counsel has what do they call it? Compassion fatigue or emotional fatigue. You've been dealing with a client who's not listening, who didn't do what you told them to, and you really just want to wash your hands of it. I get it. I've been the appellate counsel. I've been the second guy on that, and I agree with Michael. Sometimes we get a situation where, if trial counsel, and I kind of think of it as a courtesy thing. If you're trial counsel, are you really going to leave your peer, your fellow attorney hanging on what happened at trial? You were there. Tell him, hey, look, I think the judge may have missed a ruling here, or admitted evidence that she shouldn't have, or whatever it is. Pass that along. But I understand a lot of times you're tired of it. The case could have been going on for 18 months or more, depending on what the actual facts were. And there's a certain amount of fatigue. It's like, oh, I need to be done with this case. And you just don't even want to talk about it anymore by the time it gets around. But I do think it's a courtesy thing. And if you are trial counsel and you are asking for an appellate lawyer to come in and take over your duty, as we talked about earlier, to appeal this all the way to the Supreme Court if necessary, then have some courtesy and at least be prepared to give appellate counsel some idea of what he needs to look for in the transcript.
Thank you. So one of the next steps we talked about was to provide, of course, once the appellate counsel knows they've been appointed, to make sure the client knows that the appellate counsel is appointed and who they are. So
they're calling you.
Yeah, indeed. So there's a couple issues that I wanted to talk about. If no appellate counsel is appointed, or you're not able to contact appellate counsel. So what are some of the next steps an attorney should do if either they can't get their appellate counsel appointed, or they can't get a contact with that appellate counsel and get an idea of and know what they are doing on behalf of the client?
Basically, you need to step in their shoes and do what they would normally do, which is file the request for clerks and reporters records, Here in Harris County, the clerks and the reporters are pretty much on automatic, and they will generate the record automatically. That may not be the case everywhere. And of course, the problem with letting them generate it automatically is you may end up with something you didn't want, or you may end up missing something. You got to request multiple supplements. But we actually forgot to include the slide, but you may have to file a post-judgment motion. You should file a docketing statement with the Court of Appeals, which nobody does. I was complaining to Lauren about that yesterday, and she agreed with me, nobody does. And finally, if you're not having contact, you need to put some time aside, because especially if you haven't done an appeal before, it takes time. It takes time to read the record. It takes time to pull out all the pertinent facts, then try to put them in some sort of rational, cogent order. Takes time. And so you need to put some time aside, and it's accelerated. As soon as those records are in, you got 20 days to get the brief in.
Lauren, I wanted to ask the next question to you, because if a trial attorney is in this situation where they either haven't got a new counsel appointed or they can't get a hold of them, and they try to do and comply with their duties, once that case gets to the appellate court, can they then ask to be relieved of their duties and new counsel be appointed? And how does that work in the appellate court?
So yes, they can. So let's just assume that the trial counsel did its duty and filed the notice of appeal. In the appellate court system, like in our internal system, that trial attorney is designated as lead counsel. That's part of the traps about who is designated as lead counsel. So initially in the Court of Appeals, even if you're not planning on doing the appeal, if whatever attorney files the notice of appeal is designated as lead counsel. But I've had this within the last 6 months where a trial attorney did what he was supposed to do, filed the notice of appeal in Harris County. We're lucky that the clerk and the reporters pretty much automatically filed the records. But he had filed his motion to withdraw in the trial court, but could not get a ruling on it. What your option is you can file a motion to abate in the Court of Appeals. We generally will not let you just straight up withdraw from an appointment if we don't know that the client has another attorney appointed. So what we can do is we'll send the case back to the trial court for a hearing to determine, if this trial court counsel is going to continue with the appeal, if one needs to be appointed. And so that's always an option. If you're having trouble, getting out of the case, if you file a motion to abate in the Court of Appeals and explain what's happening, we will help you out. If you know that, let's say that you were the attorney that filed the notice of appeal, and then you know that an appellate counsel has been appointed, what you need to do is you need to file a motion for substitution in the Court of Appeals, because again, you are in our system as the lead counsel. And so trap 6.5 is about withdrawing and substitution in the Court of Appeals. And those motions, I will tell you, we go line by line to make sure you have all the requirements that are in that rule. They're not complicated, but it's one of those things where you need to be hitting did I do A, B, C, D? So that's an option if you know that appellate counsel has been appointed, but you're still getting notices and whatnot from Court of Appeals.
Thank you, Lauren. So I now wanted to switch gears a little bit and talk about post-judgment motions. How important are post-judgment motions, and when can they start to be filed?
You can, in these types of cases, they're typically not that important as far as preserving error. In a jury trial, if you have a jury trial, they're much more important. But post-trial motions or post-judgment motions are filed after the signing of the judgment. If you file them early, that's typically okay too. But when you're dealing with the rules, specifically the rules about judgments, 329B is the main one dealing with judgments. It's all about signing. So it's when the judgment was signed. So your post-judgment motion will be filed after the signing of the judgment.
I agree with what Michael said. Dylan, real quick, I would jump in there. The fundamental analysis there was that these really don't have a lot of applicability to what we're doing in a typical CPS case, in a child welfare case. I would say that if, some jurisdictions tend to have more jury trials than others. Some jurisdictions have bench trials. A lot of it has to do with the judge and how the attorneys interact with the judge. But some of these, another one that's not listed here includes a motion to be referred to mediation. The court does have the plenary power for up to 30 days. And now that the parties know what the outcome was of the trial, there might be the possibility of, and I have seen this happen, a request to go to mediation, and have the parent has come back and said, you know what, I've seen the writing on the wall, and I'm wondering if you would accept a relinquishment and maybe change and then reformat what the judgment was. And under those circumstances, then you no longer have an appeal. One of the neat things about mediated cases is that they very, very, very rarely appeal. And so if there is some resolution that can be had that would, be able to work around the appeal, in other words, nullify the need to proceed on appeal, then that's certainly something to be explored. But I have to tell you, that's very rare.
Are there any circumstances where post-judgment motions are helpful, even if they're not required?
Well, the nice thing about it is it gives the judge a chance to rethink the judgment. And if you can make a somewhat convincing argument, you may get the judge to change something. Maybe the judge drops a ground,
That's right.
Or maybe the judge, which makes the appeal a little bit more, the chances of winning the appeal a little bit better. Normally you'd say a post-judgment motion buys you a little time as far as the appellate calendars and all that, but it doesn't in these cases because they're statutorily accelerated. You can file them, and that gives the court extra time, extra plenary jurisdiction to decide them. And but you still have to get the notice of appeal in within 20 days, regardless of whether you file them. In a typical civil case, one of the advantages of filing a post-judgment motion is to get yourself more time. In fact, you can file one just to get more time. You don't really even need a good reason. There's some case law out there that supports that. So, but the biggest thing is, you may get the judge to change their mind.
Lauren, can you talk a little bit about how post-judgment, what kind of the effect post-judgment motions have on what the Court of Appeals does in light of the accelerated nature of these cases, which is obviously different than other civil cases, as Michael just mentioned?
It affects nothing, basically. So, the Court of Appeals has a duty to try to have a decision rendered within 180 days of the notice of appeal being filed, which is 6 months, which is a very, very tight timeline. And so we are happy that you filed them. That's great. But we just keep chugging along. So, once you file your notice of appeal, we're looking for the records. Then as soon as the records are in, we're still sending you your, notice that your brief is due in a certain amount of time. I will say that, if you happen to get your motion, I've had a case where a motion for new trial was granted, and that's great. And all that happened was then the appeal got a motion to dismiss because a new trial had been granted. So, but it changes really nothing for the operating procedures of the court and how we are dealing with these cases internally. Thank
you. So I want to now talk a little bit about sort of the post-judgment requirements, what needs to happen to preserve the appeal. And I want to talk just a little bit about, obviously we talked that they're under the rules of the accelerated appellate procedure. But what does that really mean for the court? Is there any, Lauren, I'm going to look to you. Is that 20-day requirement ever extended? If you've got that 20-day notice, are there any circumstances where that gets drawn out?
So you can file, just like a regular appeal, you can file a motion for extension. What you would do is you would file your notice of appeal in the trial court still, and your motion for extension would be filed in the Court of Appeals. The only catch is that you need to have filed your motion for extension within 15 days of when your deadline was for your notice of appeal. So essentially you might get 35 days total if you want to go out that whole extension period. But once you pass, those extra 15 days, and if you haven't filed your notice of appeal or a motion for extension, then you're out of luck. And that's because a timely notice of appeal is jurisdictional for the Court of Appeals. And so without it, we don't have jurisdiction to hear your case. The court can imply in civil cases, can imply a motion for extension. So if you miss your 20-day deadline, but you file your notice of appeal, 10 days later, well, we're in that, 15-day grace period. And we can imply a motion for extension. So that would be a situation where you would still get essentially credit for your notice of appeal, and we could still deem it timely filed.
Okay. Thank you, Lauren. I want to talk about perfecting an appeal. So what happens if you accidentally file in the wrong court?
Basically nothing.
I've
I think
never
that's what
had one.
Lauren was the one who did that. I agree with Lauren. Nothing bad's going to happen there. Just file it with somebody and get going.
Yeah.
Are findings of fact and conclusions of law, are they necessary? Are they allowed? Are they helpful? Michael, I'll look to you to answer that question.
Generally, they're not helpful, and they're certainly not required in parental termination cases. The parental and I forgot the site, but there's a rule that says findings have to be in the judgment in the rules of civil procedure. Other civil judgments, that's not the case. In fact, there's a rule that says they cannot be in there. But the reality is, if for some reason you think you need an extra finding, like maybe on, I don't know what, but you want something that's outside of the mainstream parental termination decree, maybe something to do with paternity or something to do with, I don't know, something that isn't in the normal decree, because these things come out of, hot docs. You would ask through a rules 296 to 299A, you would ask for the court to make additional findings. And the process is in there. 99.99% of the case, you're not going to need findings. And they don't extend the appellate deadlines. So don't do it if you're thinking you're getting yourself extra time or anything. If you really think you need another finding, or if there's an errant finding in the decree, then you may want to use it. But you can also attack the decree through a motion to modify, which may be more appropriate in a parental termination case. So you have those two tools to do it.
Well, we're nearly out of time, but I wanted to review very quickly sort of what are some of the critical deadlines for appeal. So we've talked a lot about that 20 days after judgment, that the notice of appeal has to be filed with the trial court. We've talked about the request for findings of fact and conclusions of law. We've talked about how that's not necessary, but that's the deadline. And then we've talked about how 30 days post-judgment motions have to be filed. And then that 35-day deadline is what Lauren mentioned earlier about filing that extension for a motion to appeal. We're almost out of time, but I did want to, we had a lot of good questions come in. We can't answer them all, and this is a bit of a pickle, but I want to get everyone's very quick thoughts on this, because this is a sticky question that we get asked all the time. What is the obligation of an attorney who has an absent client? Do they have an obligation to appeal? What is that attorney's obligation in relation to a client who either didn't appear at trial or disappears after trial?
We have that pop up from time to time. I was talking to Lauren about this yesterday, and I have two recent examples that I've seen. One is a case where, like I said, like most of the time, the trial court just assigns appellate counsel. They send the order off, and appellate counsel takes over, at least here in Harris County. And that happened. And at oral argument, the Court of Appeals asked the parent's attorney, "Have you talked to the client?" And he said, "No." And then they said, "Why not?" And he's like, "Well, I got an order that said handle the appeal, so I did." And the court, it went on for a minute or two. They were a little upset that he hadn't talked to the client, but his view was, I got the order, I go forward with it. But in that case, there probably wasn't necessarily an attempt to talk to the parent. In another case, it's a mental health commitment, but it's got the same sort of issues a parental termination case has. It's clear and convincing evidence, appointed counsel, all that kind of thing. But in that case, the committee had filed a notice of appeal pro se. And so counsel was appointed by the Court of Appeals, and counsel couldn't get in contact with the committee. She had gone back to North Carolina or whatever. And so she filed a motion in the Court of Appeals and said, I'd like to be relieved because I don't know what to do. I can't talk to the client. I don't know what exactly it is she wants me to appeal. And, you know, I just have no communication. So what should I do? And the Court of Appeals sent it back to the trial court for a hearing. And there was a hearing held on, you know, what she'd done to try to find the client, this, that, and the other thing. Point is, the Court of Appeals ultimately dismissed the appeal because the client couldn't be found. So to answer your question, that was a long way to get there. If I were trial counsel, I would go ahead with the notice of appeal. And at some point, if I still can't find the client, you know, when briefing time comes around, I would possibly file a motion in the Court of Appeals and say, I need some guidance here because I can't find the client. I don't know if I should go forward. They may not want the kid. They, you know, they may be impressed. I don't know. And that's the process I've seen happen here. But that being said, if I can't find the client, I'm still filing a notice of appeal.
I'm
Thank you
gonna,
so much.
I know we're short on time, Dylan,
Yep.
but I'm gonna jump in there and say that I think if you're gonna proceed on appeal, you need authority to do so. I don't think you proceed on appeal without authority to do so because, and Michael nailed the question. They may not want the child. You don't know what it is, and to presume that they need an appeal for something that they may not want is going a little too far. So I do think you need to contact the client. I agree that you should file your notice of appeal. But if I get to the briefing deadline and I've not been able to contact the client or the client hasn't come forward, I've done what I consider to be due diligence without any authority from the client, I am not going to do an appeal because I need to know. He may not want the appeal. And you don't know, and you are not required to presume that they do. So my answer is get authority. You don't proceed to the Court of Appeals without authority of some kind.
Well, I want to thank all of our panelists today. We're a little bit over time. I want to thank both all of our panelists and all our viewers today who participated. This was a very engaging discussion. We had many more questions than we could get to today, and we'll try to get some of those questions answered for the archive version that we will post on the Children's Commission website. For those of you who are in the future watching this archive version of the website, you can email the Children's Commission at CC Training to get the MCLE information regarding this website. Our next webinar will be March 7th regarding making and sustaining objections. We really appreciate everyone's time. I want to thank all of our wonderful panelists for an excellent and engaging presentation,